For as long as I have remembered, I have wanted to be a judge. This started when I was a young kid watching my father, who spent his entire career working litigating cases for the Iowa Attorney General's office, work from home. And like any kid, I asked what he was doing and why, and why, and why. And maybe against his better judgment, my father answered and kept answering. And that is when I wanted to enter the law. But more importantly, specifically, I developed an interest in learning about why our system is the way it is and why we do the things the way we do them. I have that interest today, and it continued throughout law school. So when I was offered the opportunity to clerk for Judge Tabor at the Iowa Court of Appeals, I was the proverbial kid in the candy store. The Court of Appeals is a very special place, and not only did I have an opportunity to learn from Judge Tabor, but also the other judges and members of the court and staff members. I had an opportunity to work on the significantly diverse caseload that comes before the Court of Appeals. But in that same time, I developed a passion for not only the people at the court, but the institution itself. I say this not only as an applicant, but as a former employee, that the Iowa Court of Appeals has been and hopefully will remain a very special place. Despite the significant and very diverse and sometimes overwhelming caseload, the court is well known throughout the state for its collegiality. I experienced that collegiality firsthand in working with, obviously, Judge Tabor, but also my fellow law clerks, staff members, and the other judges. I think that the collegiality of the court cannot be underestimated in both it making it an amazing place to come to work every day, and I enjoyed every day I worked there for the nearly 3 years I got to spend there, but also its position as a functioning institution. As you are all well aware, and I'm sure my fellow applicants have spoken about already today, the Court of Appeals spends most of its time working in panels of 3, and so it requires judges to not only express their own views, but work with others to work to the correct outcome. I believe if you ask around, I am an easy person to get along with, and while I'm not afraid to speak my mind, I would do so in a way that is respectful both of my colleagues and certainly of the litigants. I also know from my time there the work that's required. I guess for lack of a better phrase, I know what I'm getting into. I know the caseload that the court handles. I can say without reservation that I am eager to handle it. I know the diverse nature of the cases and the issues before the court requires a curiosity about the law, which I possess. It's not only just about what the record contains, but about applying prior case law and statutes to differing facts. It's about familiarizing yourself with areas or code sections that you might be familiar with, or areas of the law that you might never have seen before, and do so in a readily and quick manner. I also know that the court needs to move along as the cases continue to come in. Decisions need to be issued in a time-sensitive manner, but while still doing so in producing a well-reasoned judicial opinion. I know this is quite the undertaking for all of you. I've had the opportunity to speak with most of you in a relatively short amount of time this time around, and I thank you for your service and giving up your free time to do this. So I assume instead of letting you hear me drone on about my love for the Court of Appeals, that you would like to ask me some questions, and I am certainly willing to take those.
And we'll start those questions with Commissioner Chase.
Thank you for your application. With the bulk of the Court of Appeals cases being family law and criminal cases, how do you intend to hit the ground running, so to speak, if you're selected?
Sure. I hope it's kind of like riding a bike. I know I've been gone for some amount of time, but I think getting back into it relatively quickly from my prior experience at the court would be beneficial. And then certainly I would rely on the briefs of the parties and catch up on cases that maybe have been issued since I have been out of those areas of practice to get back in in the game, so to speak, but I think I could do that relatively quickly based on my prior experience and familiarity with those areas, even if it was some time ago.
Commissioner Boyer?
Thank you, Mr. Lindebak, for your application. I have no further questions.
Commissioner Marquardt?
Thank you for your application. So one of the other skills that a Court of Appeals judge has to have is the ability to make decisions, especially decisions in those tough cases. What about your experience has prepared you to be the person in that decision-making role?
Sure. So my current role at Grief and Sydney, I'm a partner, and for those of you who maybe don't know what my firm does, I spend a significant amount of time doing insurance defense work, and while that entails me advising and clients on Iowa law and possible outcomes and decisions if they choose to make those decisions. And so once those decisions are made by somebody else, I'm the one in charge of implementing the plans that they take. And I have control my own docket at the firm. As I said, I'm a partner. And then when it comes to trial prep, I am the one that makes the decisions about witnesses and what avenues to proceed down, or motions for summary judgment that need to be filed, and those types of things.
Commissioner DeFord?
Thank you, Mr. Lindebak. I have no questions.
Commissioner Parrish?
Mr. Lindebak, I was taken with your initial comments about being familiar and very familiar with the history of the Court of Appeals. I'd like you to address 2 points for the commission. One is, based upon your knowledge of the history of this court, can you tell us what you think this court needs now and what you bring in terms of background and experience to show that you fit that bill?
Well, I think what the court needs is what the court always needs. It needs someone who's dedicated to the court itself and to the cases before it, and someone who possesses the work ethic to work through those cases. The docket isn't getting any smaller, and I think the court needs someone that can speak about how to properly handle those cases and do so in a timely manner. I also think the court needs someone who maybe sees things from a perspective that doesn't necessarily come from a prosecutor's office or a defense counsel's office in terms of criminal matters. As you are all well aware, reading my application, I don't have a ton of criminal experience, and so I wouldn't come at it with any prejudices or biases in terms of my view of a fact pattern that maybe some members of the court might have due to just implicit bias or their judicial philosophy. As of now, I've never been a judge. This is my first time applying to be a judge, and so my judicial philosophy is I don't have one yet because I haven't been a judge. And so I don't have it's not, the correct phrase is not a burden, but I don't have a track record that I might feel I need to maintain because I said something previously. And as it goes back to the history of the court, one thing that has always benefited the Court of Appeals is the diverse practice areas from which members of the court have come from. And right now, we have seen a decrease in people who have practiced civil litigation, at least from a firm perspective, certainly. And I think I could certainly benefit the court in addressing those cases which arise.
Thank you.
Commissioner Graber?
No questions, thank you.
Commissioner Schnur?
I have no questions, thank you.
Commissioner Hanson?
Thank you for your application. The Court of Appeals deals with lots and lots of cases. How would you balance the need to process the decisions quickly, but also thorough?
Sure. And as a law clerk, was one of the things I was tasked with. There's a process that at least I had while I was working for Judge Tabor, and I will spill the beans if I happen to be selected. I will likely engage in a similar process because it worked well for me at the time, is you just take the time needed to properly read and address the arguments of the litigants and do the proper research. So it's the old John Wooden line, be quick but don't hurry. It is time sensitive. The parties are waiting for a ruling, and they wait for some time. And as someone who has done that, waiting for a ruling, it gets quite anxious both for you and for your client. But also you want to do it properly. And so I think the proper balance there is to take the necessary time to start a case and then finish the case and not get distracted by other cases in between. Certainly there are emergencies that arise and those types of things, but it's a lot easier to start and finish something all in one go than it is to work on it over time.
Thank you.
Commissioner Roberts.
Aaron, you have a good blend of trial experience and appellate experience for someone of your vintage. So can you sort of like settle the debate for us about which is more important for this vacancy on the Court of Appeals? Just joking, but talk about like how those experiences will be helpful if you're picked to be on the Court of Appeals.
Well, that's always an interesting question. If what is more important, district court experience or appellate experience? And I will say all experience is helpful at the Court of Appeals because you are passing that experience on to both people you work with and hopefully your colleagues, but also to the litigants before you. And as someone who sits in this chair answering your questions, I will tell you it's just as nerve-wracking answering the people who sit behind you and answering their questions. And so when you give those answers, I think the experience, what really helps is the ability, no matter where you're from, to clearly and concisely describe for your colleagues, the parties, and the public at whole what you are doing and why you are doing it. And so I think having jury trial experience, the opening statement for the attorneys that have given those, or the closing statement where you have to explain to a jury member who is probably not pleased that they are there to begin with because they drew the short straw, and in society's ever shortening attention span, explain to them why your case is important, why they should rule for you, and why the law that supports that. A well-reasoned judicial opinion will likely do the same thing. You tell them the facts, you tell them what you want to do, and you tell them why you did it. And I think that's helpful. From an appellate perspective, the major difference is this commission's well aware, is the Court of Appeals doesn't make the record. They are, if the Court of Appeals made the record, something went very awry. And so we rely on the district court to make that record, and that experience is wholly different than you see it as an appellate court judge. District courts make the record either as a fact finder or a finder of law, and the Court of Appeals, using a sports analogy, I think Chief Justice Roberts stole this at his confirmation, but calls the balls and strikes. And I think that's an applicable analogy for the experience level too, is the Court of Appeals is the home plate umpire, and the district court is almost the pitcher and the catcher. They're the ones that are setting the Court of Appeals up to make the call originally.
Commissioner Henderson.
I have no questions, thank you.
Commissioner Simmelroth.
I don't have any questions, thanks.
Commissioner Hartkoff.
I have no questions. Thank you.
Commissioner Spees.
Well, it always makes me nervous when people talk about vintage. But one thing that came up during our interview was discussions about the role that technology plays in cases, criminal cases with cell tower locating and GPS and DNA, discovery disputes involving electronically stored information. Does someone of your vintage have some proficiency in technology or the technological issues that face the court?
Well, I would like to say that I have a rudimentary understanding of technology, but I will say that someone of my vintage might be aging out of the people that understand the newest forms of technology and communication. Just as technology as a whole, just a comment briefly on that, I do believe that that will be a significant role in our court system moving forward, both not only the things that you mentioned, Commissioner, about trial and discovery and those things, and we're certainly seeing that in our practice, but I had the opportunity to meet with many of you over Zoom, and certainly during the pandemic, oral arguments were heard over Zoom. I think Zoom and those types of platforms are really going to significantly change the legal system as we move forward. I'm not sure if that's for better or worse. I personally like being in person. I like seeing you all in person as opposed to on a screen. I think you get a better sense of, you can tell maybe that I'm a little more nervous than I might have been while sitting at my desk. But conversely, I think there are some benefits, especially for access to justice issues and those types of things that the court will have to balance. But I think you get a better sense of the argument in the person as someone sits in front of you. But technology will always continue to play a greater role in the court system. And frankly, it has always been that way. I remember talking as I told you the story about my father, he was speaking into a dictaphone. And my hunch is that most of you have never seen someone talk into a dictaphone. And maybe not. I think that's those are just. I believe he was talking the other day, because I told him I was going to tell that story, and he told me that that was before Word Perfect. And so, if that gives you a sense of the change just in that practice, I appreciate being the vintage term. I will say that I am not old enough that I remember not having Word Perfect, but I am old enough that I remember being taught handwriting in school, which I have learned might not actually be a thing anymore. So,
Thank you.
Commissioner Hoig,
No questions, thank you.
Commissioner Stanger.
Thank you. Thank you for your application. First time around, right? Almost done.
yeah.
Getting there. So this is a big jump into public service, right? At an institution of the court, and you have some experience as a law clerk before.
Sure.
One of the things that concerns me a little bit about your application is the lack of pro bono work, or maybe your community involvement and community service. Could you maybe share or put that concern to rest with some of your other experiences?
Sure. So, like I said, my father spent his entire legal career from 1979 to 2017 working for the Attorney General's office. I certainly understand and appreciate public service. The things he did for the state of Iowa and his service, I greatly admire. Even if it wasn't, he wasn't my father, I would greatly admire it anyway. Yes, that is a hole certainly in my application. I haven't had the opportunity to do a lot of the pro bono work. One reason for that is when looking at the volunteer legal projects and those types of things, I don't necessarily practice in a lot of the areas that come up, and I certainly wouldn't want to make a client or a person who is looking for assistance be stuck with me, who would not be of any assistance at all. And so that's one reason that I simply haven't done that yet. It's not that I'm certainly opposed, but I just haven't had that opportunity. In terms of community activities, I've been involved in Blackstone and my inn of court. I've started to be more involved in bar associations and things, and I enjoy that work. I enjoy talking to the legal community. I think you can tell just by me sitting here, I tend to gab just generally as I get going. I do enjoy that work, but I acknowledge that my application does not reflect my feelings on public service.
Thank you.
And our time is up. So I appreciate and thank you for your application, and we wish you all the best.
Thank you very much. Have a good
Thank you,
afternoon.
Aaron.